They don't have no jurisdiction over me. They can't serve me, no service of process. And I outrank them in private. I have the highest ranking private civilian authority, and I literally am the executor over my estate. So at the end of the day, I'm not worried about what they're going to do because they can't summon me. I made sure to do what I needed to do and figured out how to make the claim, and I did. Took me about 4 years. It took me about 4 years to figure it out, but I figured it out.
All I can say is that status has everything to do. Under Roman law, status is everything, and under common law, status is nothing. And so I don't go there. I see Lori is on.
Hi, Glenn.
Hi, how's it going?
It's going. You know, communist Canada is crazy up here.
Yeah, it's communist Canada.
Yeah, that was ridiculous this week with the post office crap. I just can't believe them.
Yeah, I'm not surprised. I didn't know that was going on. That they had you know, I haven't been there for over 10 years. But you know, so I'm not surprised. I really don't want to talk about it too much on this public forum.
Of course, yeah, I got that.
So, but what I was thinking about is, we're actually going to hold a common law court tomorrow, and so I was thinking about going through a proposed common law court judgment, and also the fact that people are saying that it's territorial, that all of this stuff is territorial, and actually that's not true. That was actually something that I thought for a long time too, but it's not territorial. It's all Commerce Clause, and so I was going to go through that too.
That'd be great. Which case is it applying to?
Well, anything that's going on, they're getting you in the Commerce Clause, and under the Commerce Clause, you don't have any rights, and they can do whatever they want to do.
So, but you said you're having a hearing tomorrow. So, is it for a particular case or?
Well, we're hoping, you know, we'll get done as many as we can. I've got what I try and do to expedite things along is have a proposed court judgment. And so we can go through one of those, which is basically a finding of facts. And actually I have about 5 of them that I'm going to try and get through, but you know, I mean, sometimes these things can just turn into a major ordeal. Like there was some of them that, you know, that we used to do, you know, probably about a year ago, and people would go there and be there about 11 o'clock, and at midnight they'd still be there. And, you know, I'm, you know, I don't want to turn it into that kind of an ordeal. And I just want to get it done by, say, you know, 5-6 hours, and have done whatever we're going to do. And then otherwise we just meet again. Because you don't want to, you know, most people are there on a voluntary basis. You don't want to turn it into an ordeal. And
no, of course not. Where's this being held?
Well, we're going to do it in an IHOP. Actually, they have a separate room, and of course everybody has to buy something. But it's a separate room, and they have power outlets, and so we can sit there and talk and conduct our business in privacy. And um, then once we're done, you know.
Nice organization that you've managed to gather people to come together like that. That's nice.
There's a lot of people in this area that are, I would say, patriotic, that are concerned about things, and there's a lot of people here. This is Texas. So there's a lot of people here that are, yeah, a lot more than a lot of other places for sure. You know, there's no way we could, you know, I doubt I could get, if I was in Phoenix, I doubt I could get enough people to do what we're going to do here. But here, you know, I mean, what we do is we limit how many people we invite, just so we don't attract too much attention to ourselves. You know, so we'll see. So, but we could get a lot more people to come, I'm sure. There's a guy that's offered us a commercial building. The only problem is there's no chairs, but we could probably fit 50 people in there. We could have a TV and do a presentation, and there's nothing to sit on. There's another guy that, I don't know if you've heard of David Straight.
Oh, absolutely, yeah. But get everybody to bring their lawn chairs. That's what they do up here in Commie World.
That's not a bad idea. But anyways, David Straight, I know him personally. He's actually a friend. I don't agree with a lot of the stuff he says. He talks about changing your status and all that. I don't think it's necessary. And so, and I know Bonnie, his wife. I've known Bonnie longer than I've known him. And so, but they have a building that is perfect for this kind of stuff. It's just a little bit off the beaten path. And we could fit 100 people in that building, and there's seating and everything we'd need. But there's, you know, so it's a little bit of a drive. It's probably about 20 miles away. And, but it's perfect because, they brought forward, I helped Bonnie actually bring forward the land patent on that building. And they've been trying to steal it from her, but they can just never do it. And because I think it's because of that land patent that I helped them with.
Yeah,
anyways,
David's talked about it. He's talked about that building and their attempts. Yeah.
So anyways, yeah. So as soon as we get a few people here, I don't know how many people are here right now. It looks like there's 2, 4, 6, 8. We can start anytime you want to start, basically.
Okay, I'll read that notification and then we can start going over the cases. I was going to invite a few more people, and but no, let's go. Let's go.
We can wait till they show up if you want. I mean, I'm flexible. I'm
Are you
available now.
You're good for tonight. You're not out to any inventions or anything like that. Again.
No. I'm at home. I'm sitting here at my computer, and so I'm here basically for the night.
Okay, good. I will. I'll invite some more folks, and then you can let us know about your job interview that happened a couple weeks ago.
Yeah, that one went okay, but I haven't heard anything back.
So,
but
was it for real, or were they digging for information? What do you think it was about? Was it regarding your engineering work or law work?
Oh yeah, for sure. Oh yeah, for sure. Yeah, definitely. Yeah, they wanted to know what kind of experience. He only had like 5 questions for me, and I probably should have elaborated more. But he wanted to know how good I was at Microsoft Excel, And there was some other software he wanted to know, if I was familiar with. And I was actually familiar with all of the stuff that he talked about. I've had training in Microsoft Excel. I can do anything. Microsoft Excel is a very powerful program, and it's amazing some of the stuff you can do with that. But I actually built a pressure drop analysis spreadsheet where there's 4 different kinds of hydraulic fluid, and you select which hydraulic fluid you want to use, and then you pick a temperature and you pick a pressure that the system operates at, and it'll tell you the pressure at any part in a system, and it takes into account all the bends, all the fittings, all that stuff. And it's pretty slick. And I built that spreadsheet. It's an Excel file. That's what it is. And
you mentioned that to them, obviously.
Yes, I did. Yeah. And see, the only thing I would have trouble with is Microsoft Excel. You can there's macros that you can put into the thing and import data from an external database. And that I don't have a lot of practice with that. I need to work on that. But that's the only thing that I'd have any trouble with at all. Anything else, I mean, there's no problem. I've done it. I mean, it's amazing what you can do in Microsoft Excel.
I know it's highly technical work. When I was working with you and we were switching, or I was sending my affidavit back and forth, you were stumping me on all of the tools that were needed in order for me to not just make the changes, but just send it back and forth that we could work on this document together. So I ended up getting really frustrated because I didn't even know how to do all that. So I ended up putting that aside, and I took a programming course so I could even understand it. And that was like a 6-month ordeal, just understanding the programming language. So if you're doing that kind of technical stuff, that's like building data spreadsheets, that's highly sought after work. Very
well.
excellent.
There was a guy when I was working in Delaware. There was a guy there that was good at the macros, and they would bring them in just to import data into Microsoft Excel from other databases, because there's a lot of database programs that they use in these companies and stuff. And he would import data, and then once you have that, you import it, and then you can make charts. You can do all sorts of neat things with it. And but you have to be able to import it first, and so he knew how to do that, and that's why I actually took a training class in Excel, because I wanted to learn how to do that. And I did learn how to do it, but I haven't had much practice with it. And so, it's been a while since I took that training class, but everything else I already knew. And so it was no problem. But Microsoft Excel is I went, when I was working at US Airways, I built a spreadsheet that was all the life limited parts on 3 different aircraft types, on 737s, 757s, and Airbuses, A319s, A320s, A321s, and A318s. And the Airbuses, the landing gear are very similar, and a lot of times they're interchangeable, but only under certain circumstances. And so the spreadsheet defined everything as to when you could put this landing gear on this airplane, and then it tracked all the life limited parts. And there's a lot of them, because what happens is that they're required to do fatigue testing on the landing gear, and none of them do it. Boeing did it on the 747, and so the 747 landing gear are not life limited. But on all the other airplanes, they didn't do the fatigue testing, and so therefore they put a life on the parts. And so they're all parts that are considered principal structural elements, and so they're important for the gear. Anything that's secondary structure or something like that, they don't worry about. But so you have to know what the principal structural elements are of the gear, and there's actually a place that you can go and it'll tell you what all the parts are considered principal structural elements, and so and then the life on those parts. And then that was another thing I did at US Airways, is I set it up in their computer system so that they were tracking. So then every time the airplane landed, it was a cycle was attached. And so then what would happen is, the pilots would fill in the logbook, and the logbook would go to be turned into maintenance control, and maintenance control would input the data. And so every time there was a cycle, it would be put in the system, and it would automatically track. And so then what would happen is when it's getting ready to be replaced, then there would be a work order put out, and it'd all be done by the computer, and a work order saying replace this part. Usually they would schedule it for, like, these parts are pretty serious, and so they have to, some of them, like landing gear is, sometimes you have to do a whole gear change or something like that. And so that'd be scheduled at a heavy maintenance visit so that the airplane's down anyways, and so they do a gear change while it's there. And so and then I had to deal with the vendors and make sure that they were complying with all of the regulations. But anyways, I built this spreadsheet, and the FAA loved it. Matter of fact, they wanted a copy. And it had all the life limited parts and their interchangeability, and everything was all set up in there about what was interchangeable with what and what wasn't. And it was all set up in that Excel file, and it was just an Excel file.
So it was open source for the company?
Well, it's all, Boeing, for Boeing airplanes, Boeing publishes the information, and with Airbus publishes it. And so then all I did is I compiled the information and put it into an Excel file, all the possible part numbers, like, for example, the main strut, the assembly. There's an assembly, and then there's an inner cylinder and an outer cylinder, and so on. There's a part number, and there's only certain, and there's all the possible part numbers that could be possibly used, and whether they were all interchangeable with each other or not, and that kind of thing. And so it took me months to put that spreadsheet together, and but I did, and they really liked it.
Well, I'm sure they did. That was biggest part of business is through their communications. So you helped organize that. That must have been. I hope you got the credit in all of the write-ups and testimonials about it.
Well, what happened is I got into a battle with the IRS, and they started stealing my compensation. I would have been good. I would have been set. I would have never had to look for another job in my life. That's the longest job I ever had in my life, too. I worked there for like about 7 or 8 years. But what happened is I got in a battle with the IRS, and they told US Airways to start stealing my compensation. And, long time ago, I learned that if you don't pay me, I'm not going to work. So no pay, no worky. So I quit.
Garnished your wage? They garnished you?
Oh, I wouldn't call it garnishing, quite frankly, but they told I had put myself down for maximum exemptions, and they told US Airways to change it to 0 exemptions. So I went and I filed a lawsuit against them and US Airways, and it went all the way to the Supreme Court. And I actually sued the IRS twice and took them to the Supreme Court. And it's 2 of my 5 lawsuits that I took to the Supreme Court. And the IRS doesn't want to talk to me now. And so they don't ask, I don't tell. I filed $15 million commercial lien against all the commissioners and deputy commissioners of the IRS. And I filed criminal complaints against them. And George Bush had Mark Everson was the commissioner of the IRS on the White House lawn, saying it was the toughest job in the country. And I think it was because of stuff I was doing, but they'll never tell me. And he had to resign, and they had an acting commissioner in his place. And so an acting anything is when the guy leaves before his term is up.
You wore him down.
I guess, I don't know, but I filed commercial liens against them, criminal complaints, and I wound up leaving U.S. Airways. That's when I went and started working on the F-35 Joint Strike Fighter.
Well, that's their loss. That's their loss.
Well, so anyways,
successors and all successors and heirs are acting. A sentence where they're also acting too, right?
Sorry.
Oh, there's that. You said the acting, representative, the one that's taking over the position. I was just wondering if it was like there was a sentence that says like all actors or successors and heirs. It applies to them as well. If you write that sentence in your.
No, I didn't. No, but what happened is
anyone in the seat.
What happened is they. I had the Pennsylvania Attorney General removed too, I think, and there was an acting Attorney General. So they have a normal time period. Any commissioner with the IRS, it's a 5-year appointment, and so if they leave before the 5 years is up, they have an acting commissioner put in his place until the 5-year term is up, and then there's a new appointment. With the Attorney General, they have an election, so their election's good for 4 years. And so if they leave before their term is up, then there's an acting Attorney General, and so I filed criminal complaints. What happened with the Attorney General is I was living up in New York at the time, working for Atlas Airlines, and sending notices out to all of the people I might have to deal with. And what happened is I sent one to the Pennsylvania Attorney General. One of his flunkies sent me a letter back saying, if you drive, it said it was a short notice. It was like maybe 8 pages, 10 pages. And it said, I'm going to be traveling in your area and I don't have a driver's license. And one of his flunkies sent me a letter back saying, if you drive in Pennsylvania without a driver's license, we're going to arrest your butt and take you down and put you in jail. And I went and made up a criminal complaint, and I said that for perjury of oath, treason, sedition, that kind of stuff. A short criminal complaint. I attached their letter and my letter, and I sent it to the U.S. attorney in Harrisburg, Pennsylvania. 2 weeks later, I get a letter back saying we've referred this matter to the FBI. And 6 months later, I'm looking on the Pennsylvania Attorney General's website, and they have an acting Attorney General. So, they don't ever tell me anything, but I think that it's amazing how many times I do that stuff and things like that happen. I'm going to step away for a minute. I'll be right back.
It's a pretty interesting story. How that worked out. I can't wait to hear the end of it. Unless I missed that. My internet went out.
He's worked for all the big airline engineers in, U.S.
Oh yeah, I realized that. I was just saying what you were saying about he got the letter back saying you better not drive, and then he sent another letter back saying, well, here's someone else's opinion on it.
He doesn't mess around.
One of his flunkies, one of the AG's flunkies.
So anyways, what I wanted to start off with tonight was the fact that it's Commerce Clause. A lot of people are saying that it's territorial, and that was actually something that I thought in the past too. I've told people it's territorial, but in the territories you have rights. If you read the Northwest Ordinance, which is it applies to any federal territory. It could actually apply in Texas because Texas is under military occupation, which makes it federal territory. And so you could actually, plead Northwest Ordinance. But actually what they're doing, and most people don't realize this, is they're using the Commerce Clause. And that's a diversion. Okay, the territorial stuff is really a diversion. And the reason, the way they're using the Commerce Clause is zip codes and Federal Reserve notes. That's all DC. That's all belongs in DC. Zip codes are DC, and Federal Reserve notes are DC. And we'll talk about that. I was going to go through one of these common law court decisions that we are probably going to talk about tomorrow, and it goes through some of that about why it's Commerce Clause. So really, a criminal complaint for perjury of oath for bringing the District of Columbia outside of 10 miles square in violation of Article 1, Section 8, Clause 17. That's where I go with it, and I accuse them of involuntary servitude, the felonies associated with that, slavery, which is involuntary servitude, all of that stuff. And so I don't know if you want to go through, we can go through one of these. I'm just trying to think of which one I want to go through. I should probably go through.
Yeah, just let me read this opening statement prior to your starting so we don't have to do any repeats.
Good idea.
Yeah, okay, well, I'll start with the, what do we call it? The announcement. So this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an inappropriate manner. Shall be addressed in an inappropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency or federal, state, country, or county, city of town or township agency present? This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Raise your hand, say your name, and state your position. No one? Awesome. Okay, one more time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an inappropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or an agent of any law enforcement agency of the federal, state, county, city, or township agency present? This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Raise your hand, say your name, and state your position. Perfect. Last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an in an inappropriate manner to eliminate all conflict, false allegations. Is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, township agencies present? This is also for a notary, poll worker, school board member, anyone who has signed an oath to the de facto government. Raise your hand and say your name and state your position. Great. Looks like we're all clear. Thank you very much. Go ahead, Glenn.
Okay, so what I'll do is I'll share this document that
You're going to share your screen?
yeah, now yeah, this is actually a case that this lady was convicted in a kangaroo court, and so this is all public information anyways. She's trying to get another trial in the kangaroo court, so we'll see. But so that's why I'm going to talk about this one, because and we actually already did one, but it had a different seal. You see this one Supreme Court, United States of America Justices Court. The one that we used previously was common law, a common law court seal, and they kind of it didn't seem like they really paid much attention to it. And we know that this one worked in Dallas in the mid 90s, and so I made a seal just like the one that worked in Dallas in the mid 1990s, and that's what this is. So Republic of Texas, our one Supreme Court, common law venue. So then obviously our one Supreme Court doesn't necessarily need to be in common law, but that's where we're doing it. Original and exclusive jurisdiction, a superior court sitting with the power of a circuit, and United States District Court in and for Tarrant County de jure, Texas Republic, United States of America. And so I'm patterning this after that common law court case that was upheld by the cases, the courts here in Texas in the mid 90s. And so I'm basically doing the same text, except that it's not, we're adding in a bunch of facts. And the reason is that under the 7th Amendment, no fact found by a common law court can be otherwise be re-examined by any other court except by rules of common law, and none of them can even go into common law. So they can't even dispute it, what we're saying. All the federal courts are all equity. They're all equity. It's all martial law. And so anyways, so this is the text is identical to that with a few changes that we made, but generally it's identical. So people in for the United States of America, ex-rel, Deborah May Carter, demandants, and this is in law, our one Supreme Court, case number, private judgment, lien notice, Lori Varnell, Elizabeth Beach. Okay, Lori Varnell's an attorney. Elizabeth Beach is the judge. Nathan Martin, Anastasia Frank, Harry White, those were all attorneys. The state of Texas, Inc., and the county of Tarrant, Inc. To all appellate subdivisions. And so what happened in 1995 is there was a lawyer that actually helped him with that. His name was Jerry. What was his name? Jerry. Anyways, he ultimately got disbarred, and I think it was because of his involvement in that. Jerry, I'll think of it here in a little bit. It's actually on that judgment, and that's been uploaded. It's pinned and on the group on my page. So anybody can download that, and it's 45 pages, so it's not like it's that long, and you can look through it. Anyways, so to all appellate subdivisions of the appellate jurisdiction of the Supreme Court of the United States, to all financing institutions of the United States and their agents, subjects, Now, one of the things I am actually bringing an action against John Roberts, and the reason this is so powerful as our one Supreme Court is because the Supreme Court that's in the District of Columbia is not legitimate, and it's full of bar members, and when they have a meeting, they have a conclave. Okay, that's all a Vatican, so they're not legitimate, and they know it, and so this is the only legitimate Supreme Court. It's not like we're taking anything from them. I'm not to say that they're not giving out some good judgments, when sometimes they give us good judgments, but I think that we need to consider that a gift, and because it's still a Vatican. It's still a Vatican, and they're a bunch of, don't get me going. Some of them on there are good people, but there's not all of them are, and
they're foreign.
Yeah, exactly. So anyways, people in and for the United States of America, for Tarrant County, Texas Republic, our one Supreme Court exclusive to the people, original jurisdiction, did speak and was placed into evidence after reviewing the evidence and hearing testimony, hereby attest and acknowledge the finding of facts to be true, correct, certain, and relevant against the wrongdoers in this judgment, and as follows. Okay, so remember, they're called wrongdoers. Okay, at common law, that's what they're called. Okay, and at common law, we're called demandants. Okay, so we're not begging, we're not asking for something, we're demanding. Okay, that's what the people do. The people demand. Time to get off your backside, bureaucrats, start taking care of business. And so we're demandants. So fact one, affiance being posterity is found in the preamble. And so we the people of the United States, and we all know what that says, and do ordain and establish this Constitution to provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America, are entitled to right of blood. Okay, right of blood's a maxim of law. Right of blood means that no civil law can violate right of blood. So we're
So you're not worried about coming off as an enemy combatant.
That's right. We're coming off as the boss. We're the boss. Did charge wrongdoers for the fraudulent works, wrongdoing, and witness wrongdoers, deny due process of law, deny trial by jury, deny assistance of counsel of choice, deny advocate under Americans with Disabilities Act, deny challenge to jurisdiction, deny access to exculpatory evidence, and failure to explain nature and cause of the accusation, failure to provide compulsory process for obtaining witnesses in her favor, failure to provide discovery of evidence being used against her, made false statements testifying to the jury based on a fake indictment, which we, the jury, have reviewed and say state of the form is common law, and other certificates, documents attached. Fact number two, the authority the wrongdoers are operating under derives from we the people. And this is another maxim of law, that which is derived, the power which is derived cannot be greater than that from which it is derived. Fact number three, it's impossible for we the people to delegate an authority over we the people. This is McCullough versus Maryland. And that basically the sovereignty of a state extends to everything which extends by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think not. Demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And this is so powerful. That's why they got to get you into the Commerce Clause, I tell you, because they don't have a leg to stand on otherwise. They got to get you into a contract. And here's again that the power which is derived cannot be greater than that from which it is derived. Actually, we could probably take that out of there because it's already in there. Nor does the conclusion by any means suppose the superiority of the judicial to the legislative. It only supposes that the power of the people is superior to both. The sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. So, fact 4, this Constitution for the United States of America is the supreme law of the land, notwithstanding any state constitution or law, and requires trial by jury, due process of law, to be informed of the nature and cause of the accusation, compulsory process for obtaining witnesses in his favor, assistance of counsel choice. So what happened is there was several of us that went down there and witnessed all these denials going on. And so we just made short little filings, little statements under penalty of perjury and filed them into the case. And so that judge is they knew that they didn't like that, and they couldn't do anything to stop it. And so they knew they had a problem. Matter of fact, she's asked for another trial, and so we'll see. I think they're probably going to give it to her. Fact, County of Tarrant and the state of Texas are District of Columbia corporations, as evidenced by their use of a zip code. And this is found at the Code of Law for the District of Columbia, 31 Stat 1190. The said Supreme Court shall divide the said district into 10 subdistricts and prescribe the place in each subdistrict where the justice thereof shall have his office for the transaction of business. So again, that's where the 10 regions are. Okay, that's what that's all about, and that's why they use a zip code. And their use of Federal Reserve notes that are intended for use in the District of Columbia only. And this is Gold Reserve Act of 1934, 48 Stat 344. As used in this act, the term United States means government of the United States. The term currency of the United States, okay, so the term currency of the government of the United States, which means currency which is legal tender in the government of the United States. That includes United States notes, Treasury notes of 1890, gold certificates, silver certificates, Federal Reserve notes, and circulating notes of the Federal Reserve banks and national bank associations. So I mean, that's District of Columbia, and this is codified at 12 U.S.C. 411. And Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through the Federal Reserve agents as hereinafter set forth, and for no other purpose are authorized. It's all District of Columbia. And have waived any immunity they may have enjoyed. And this is Clearfield Trust Company versus United States. Governments, any sovereign, descend to the level of a mere private corporation and take on the characteristics of mere private citizen, where private corporate commercial paper, Federal Reserve notes, and securities, checks is concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government. Fact, every state is entitled to a republican form of government. That's Article 4, Section 4 of the Constitution. Fact, we the people failed to be U.S. citizens because U.S. citizens failed to exist when the Constitution was written. The term citizens of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced, and the several states had assumed their sovereignties. Before this period, there was no citizen of the United States. It might be correctly said there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. And a U.S. citizen, Fact 8, a U.S. citizen is a business entity, includes the minor estate at 31 CFR 363.6. And this is Public Law 100-418, August 23rd, 1988. Definitions, as used in this section, the term United States business means a United States citizen or a corporation, partnership, or other association created under the laws of the United States, or a foreign corporation. So again, a United States citizen is a business entity. Fact, Congress set up an unconstitutional municipal corporation in 1871 at 16 Stat 422 called United States as a government for the District of Columbia. Fact, Congress ceased to have a quorum when the southern states walked out of Congress in 1861, and Lincoln ordered them back under executive authority, and Congress has been operating as an unconstitutional municipal let's add that in, I guess. Municipal corporation ever since. And this is Downs versus Bidwell, the dissenting opinion. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. Okay, so Congress is operating the District of Columbia. That's all coming from Congress. Fact 11, the unconstitutional municipal corporation that was set up in 1871 has not had a treasury since 1921, 48 Stat 654, and its treasury is now the International Monetary Fund. Presidential Documents 29 number 4, page 113, 22 USC 285 to 288, which is an agency of the World Bank that is owned and operated by the Vatican. And this is a quote from Roman Catholic Archbishop James E. Quigley in the Chicago Daily Tribune, May 5th, 1903. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And this is Jewish Encyclopedia, 1901 to 1906, Volume 2, page 497, and a somewhat curious sequel to the attempt to set up a Catholic competitor to the Rothschilds, that at the present time, the latter, the Rothschilds, are the guardian of the papal treasure. So this is all coming from the Roman cult. All bar members are foreign agents of the Vatican, and this is Inns of Court. There's certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. Black's Law Dictionary, 5th edition. Because Inns of Court is one of 4 law schools located in the city of London, and because the city of London was never conquered by William the Conqueror, circa 1066, and King John agreed to pay the Vatican tribute. And this is concessions of England to the Pope in 1213. And you can read that. I'm going to keep going. But it's paying tribute, which precipitated the Magna Carta of 1215. And this is a Canadian case, Perlman versus Pichet and Attorney General of Canada, reference habeas corpus. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we cannot say it was concluded between 2 legitimate and independent sovereignties, nor between 2 nations, nor is it a law. The barons do not appear in it as subjects, for they are freed from their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between 2 nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. So think about it. What they essentially did is they stuck a sword to his throat and they said, "Here, king, we want you to sign this." And that's kind of like what they did with in Texas with Santa Anna, right? They went and conquered Santa Anna and made him sign the independence of Texas, and which precipitated the seizure of the kingdoms of England and Ireland and bankruptcy for failure to pay the tribute. And so then the Magna Carta, all this stuff in the Magna Carta, you look, it's all about collecting money, okay? So they were trying to get the tribute to pay to the Vatican. City of London shall have all of its ancient liberties and free customs, okay? Furthermore, we decree and grant that other cities, boroughs, towns shall have their liberties and free customs. So they were charging money to go into these cities and towns. No individual shall be compelled to make bridges on at riverbanks except those who from old were legally bound to do so. No sheriff, constable, or coroners or other of our bailiffs shall hold pleas of our crown. Okay, think about it. That's what the cops do on the side of the road. Okay, no sheriff, constable, coroner, or others of our bailiffs shall hold pleas of our crown. They're holding a plea. They're making you give evidence against yourself. No constable or other bailiff of ours shall take corn or other provisions from anyone without immediately tendering money therefor. They were seizing people's property, unless he can have postponement thereof by permission of the seller. No sheriff, bailiff, or other person shall take the horses or carts of any free man for transport duty. They were saying, well, this is your transport duty against the will of the said freeman. Neither we nor our bailiff shall take for our castles or any other work of ours wood, which is not ours. They're seizing people's property again. No bailiff of the future shall upon his own unsupported complaint put anyone to his law. Well, that's what they do on the side of the road. Think about it. Without credible witnesses brought for their purpose. Okay, there's no witnesses to this crime. To none will we sell, to none will refuse, delay, right, or justice. Okay, they sell justice every day in these so-called courts. Okay, that's what the filing fee is, which means the City of London is now owned and operated by the Vatican. All courts, fact 13, all courts are ecclesiastical, being under the direction of the Vatican. This is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. Use. Okay, that's short for usufruct. Thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult. That's the same thing that's going on today. To be bound in conscience to account to assess use for the rents and emoluments of the estate. That's taxes, folks. Anyways, and it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And this is found in volume 2 of Tomlin's Law Dictionary, 1835 edition, under the definition of mort main. That law dictionary doesn't have page numbers on it, so that's the only way you can find it, is you got to look up mort main, and then, and mort main, the definition of mort main is like about 4 pages too. Anyways, that facilitated the disappearance of the true Article 13 and Amendment, and this is the true Article 13 and Amendment. This titles of nobility. By Abraham Lincoln, who was a bar member and would have been prevented from holding office as President of the United States, as further evidenced by the statue to Abraham Lincoln that has been erected in the City of London in tribute to him for eliminating their true Article 13 and Amendment problem. I don't know. Did you know there's a statue to Abraham Lincoln in the City of London?
They've got a bunch of weird shit there.
Fact 14, because of the disappearance of the true Article 13 and Amendment, bar members have been able to infiltrate throughout the country and seize control, because all attorneys and almost all judges, state and federal, are required to be a bar member and 70 to 90% of all legislators, federal, state, and local, are bar members, all of which is confirmed by the Bar Treaty of 1947. Fact 15, the minor estate entity originated with the Vatican. Okay, and that's Tomlin's Law Dictionary again. And it was introduced in America at Chapter 56 at Section 1617 and 31 Stat 1432, where it says the legal estate to be in the Sisticae use. Remember the Sisticae use again. I'm going to step away and I'll be back in a minute.
I've got to ask Glenn. He's got the Sisticae Trust mentioned all in his paperwork, but he doesn't want to change his status or doesn't believe in that avenue. And he believes it's not needed. My view is that we just don't mention it in open court at all. But he's doing this in a common law forum, so I'm interested to see how it's going to go down.
Okay, so I'm back. Now, I was actually thinking that I might upload this file to the group, and this is page 7. Let's come back here.
Yeah, please do.
This seal right here, it's a JPEG file.
And I
And
wanted
so
to ask you how
anybody,
you created it through the
yeah,
through a font.
well, no, what I did was I actually paid to get it created for me. Staples made it for me. They actually made a JPEG file, not a JPEG file, a PDF file, and they made it in black. And so then I had to make it red. I like red is better in my opinion. I think that's more that's de jure, lawful de jure. Anyways, so I made it red, and but so if I upload this thing, then anybody can take that thing. Anybody in the USA can take that and use it, and because that could be used anywhere in the USA, and make your own common law court judgments, and get 12 people, and you got to have a bailiff and a clerk. So yeah, you can, and just follow the pattern in that 1995 case. So let's go back to page 7.
That's very gracious of you. Thank you, Glenn.
Well, it's a networking thing, and we need more people doing this stuff. And so,
So you have more than
it's
12 coming tomorrow. More than 12 folks going to be.
we hope to. I guess we'll see. We won't know till we get there.
Got it.
So, anyways, so at 31 Stat 1432, where it talks about the legal estate to be in the Sisticae use, and a use is short for usufruct under Roman law, which is a type of trust, and a U.S. citizen. Minor estate entity is a taxpayer. And so then this is a summary of this Henry Boland's case. Every taxpayer is Sisticae trust having sufficient interest in preventing the abuse of the trust to be recognized in this field of the court, this court's prerogative jurisdiction. And then this is 5 pages. This is a summary of 5 pages of the congressional record. If anybody's ever seen the congressional record, it's fine print. It's 3 columns, and there's a lot of stuff. So this is just a summary. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Sisticae Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And so, and then ex parte Frank Knowles, it might be correctly said, and we already showed this one. that there's no such thing as a U.S. citizen, which means it's bondage, and the Vatican is using it to enslave everybody. The unconstitutional municipal corporation operates under Roman law, and Roman law, civil law, Roman civil law are convertible phrases, which is talking about municipal law. Fact 17, Congress unconstitutionally converted itself over to the foreign enemies, the Vatican, and their owned and operated World Bank and its agency, International Monetary Fund. Matter of fact, I think I'll change that to a lower a. Through the bankruptcy. It's established fact the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. Isn't that wonderful, eh? 18, the World Bank and their agency, International Monetary Fund, and their owned and operated United States Department of Homeland Security, Secret Service, and their unconstitutional municipal corporation, United States, are all foreign enemies. And again, this is that dissenting opinion, Bounce versus Bidwell. Fact 19, the Vatican, through the World Bank and their International Monetary Fund agency. Maybe I'll change that. Created the minor estate entity in the demandant's case, Deborah May Carter in the demandant's case, by fraud and deception for the purpose of enslaving the demandant under the Commerce Clause. See, it's all about the Commerce Clause. If you look up the definition of an entity, we should have it in here somewhere. Anyways, Article 1, Section 8, Clause 3, and then they can call it a contract. Fact, the wrongdoer, Deborah May Carter, is a minor estate treasury direct account created by fraud, deception, treason, and perjury of oath by Janet Yellen and her predecessors, 31 CFR 363.6, and a seditious conspiracy with communist sorcerers and hospitaliers peddling pharmaceuticals when the demandant was born by her mother. Fact 21, hospitaliers or sorcerers peddling pharmaceuticals from the Vatican, because the Greek derivative of the word sorcery is pharmakeos. And this is Tomlin's Law Dictionary. Maison Dieu is a house of God, a monastery, a religious house, or hospital. The word is mentioned in 39 Elizabeth. Okay, that's English statutes. And then hospitallers were knights of a religious order, so called because they built a hospital at Jerusalem where pilgrims were received. And then contraformum, whatever that is, a writ that lay where a man had given lands and perpetual alms to any lay houses of religion, as to an abbot or convent, or to the warden or master of any hospital. So a hospital is a religious house. And his convent to find certain poor men with necessaries and do divine service. If they alienated the land to the dispersion of the house and church, then the donor and his heirs should bring the writ to recover the lands. Okay, so this is other stuff. But anyways, the point is that a hospital is a religious house. All superior courts of general jurisdiction are presumed to be acting within jurisdiction till the contrary is shown. And this is Vermont court case. A court of general jurisdiction is presumed to be acting within jurisdiction till the contrary is shown. Denial of due process of law, deprive any court of subject matter jurisdiction. And this is some other court cases. Federal court cases. This is a federal court case, and both of them are federal. Not a reaction by any judge is an exercise of his judicial function. It's not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force or effect. Where a court failed to observe safeguards, it amounts to denial of due process of law. court is deprived of juris. All judges hold office.
Isn't that all absent? Okay, go ahead.
All judges hold office during good behavior. Article 3, Section 1. All judges are required to be neutral and unbiased. Any judge or officer of any court who fails to be neutral or unbiased or denies due process of law, forces entry of a plea, denies assistance of counsel of choice, denies compulsory process for obtaining witnesses in her favor, denies trial by jury, denies access to exculpatory evidence, fails to explain the nature and cause of the accusation, makes false statements testifying to the jury or to the court, denies any of the requirements in the supreme law of the land, is in bad behavior and ceases to represent the government and is operating in their private capacity, and also who acts in violation of the Constitution.
Can I ask you a question? May I ask you a question?
No, actually, I'm talking about this, and
No problem.
Yeah, let's wait till
What was the
Glenn's
question?
finished going through this.
What was the question?
Very important to understand that stuff you're talking about there is all absent contract. If there's a presumption of something contract, the judge's hands are tied. Now that the Chevron deference case has been overturned, and we know this because this case has been overturned, that the ambiguity of law now can be put back in the judge's hands. So we know before that, before it was overturned and it was lobbied to put in place, none of this applied because there was a presumption assumption of contract, Glenn.
Actually, we're not talking about contract law right now. We're talking about what this common law, okay? This is common law, okay? And so the common law court can do anything they want, and they don't need permission from some judge or from even the so-called Supreme Court, okay? And so we're talking about common law right now. And if you want to go into an admiralty court but see, this common law court is superior to any of their admiralty courts, and they bow down to it. And if you took the time to go and look at that case that was upheld by Dallas in Dallas, Texas, you would see that that's what happened. And they talk about other cases that were upheld as well. So that's really not the topic of the discussion today. And so let's continue. Let's continue. And if there's any more outbursts, I might have to mute somebody. Anyways, so it goes on to they're operating in their private capacity. See, that's the beauty of the common law, okay? And under the 7th Amendment, any finding of fact by a common law court cannot be reviewed by any other court, and except by the rules of common law. And so it really is powerful. And if you read that, take the time to read that WFAA TV case, you'll see how powerful it was. WFAA TV had to go bankrupt, and they talk about other cases where a bankruptcy court ordered somebody's property returned to them that had already been auctioned off. Anyways, but that's not the topic. We're talking about common law here right now, and I agree that the Chevron deference case, but it's not being equally enforced. I hope it starts to get the things start turning around. It looks like things are turning around, but meanwhile, it can't all come from one guy. Okay, President Trump and even Thomas on the Supreme Court and Gorsuch. It can't all come from one guy, and it's got to come from we the people. And so this is we the people standing up and making a statement, and that they cannot dispute. Anyways, so let's continue. Elizabeth Beach is a judge of the Tarrant County Criminal District Court 1, and Lori Varnell, Nathan Martin, and Anastasia Frame are assistant district attorneys for the Tarrant County Criminal District Attorney, who brought an action against Deborah May Carter for money laundering under federal statute 18 U.S.C. 1956, amounting to theft under the Texas Penal Code. All federal and state statutes are void for vagueness and overbroad. it's a basic principle of due process that an enactment is void for vagueness if its prohibitions are not clearly defined. Vague laws offend several important values. First, because we assume that man is free to steer between lawful and unlawful conduct, we insist that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. Vague laws may trap the innocent by not providing fair warning. Second, if arbitrary and discriminatory enforcement is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis, with the attentive dangers of arbitrary and discriminative application. Third, but related, where a vague statute abuts upon sensitive areas of basic First Amendment freedoms, it operates to inhibit the exercise of those freedoms. Uncertain meanings inevitably lead citizens to steer far wider of the lawful zone than if the boundaries of the forbidden areas were clearly marked. And this is U.S. versus McCausey. Due process requires statute to be sufficiently clear so as not to cause persons of common intelligence necessarily to guess at its meaning and to differ as to its application. And related to, but distinct from the vagueness doctrine, is the doctrine of overbreadth. A law is overbroad if it prohibits not only acts the legislature may forbid, but also constitutionally protected conduct. Henry White and Kevin Russo are public defenders who were forced upon Deborah May Carter after she was impoverished with an ankle monitor and was under house arrest for 3 years and prohibited from leaving for anything, including work or church. Harry White and Kevin Russo admittedly billed for 16 and a half hours over 39 months and told Deborah May Carter she would be found guilty, and they were there to mitigate the sentence. Elizabeth Breach allowed Deborah May Carter to fire Harry White and Kevin Russo on the first day of the show trial after a demand to disqualify the judge was filed into the case. That's one that I filed, by the way. Accusing Breach of running a star chamber. The corrupt Star Chamber courts of England required defendants to have counsel. Star Chamber stood for swiftness and arbitrary power. It was a limitation on the common law. The Texas Penal Code and Title 18 of the U.S. Code are penal codes. Any penal action is a civil action for breach of contract. That's why I like doing this common law stuff, because I don't really care. We, the jury, decide the law, okay? And I don't really care what they say, okay? I mean, I'm just providing these court citations as a courtesy to show that we're not completely off base. But it really doesn't matter, because we can be completely off base, and there's not a damn thing they can do about it. Anyways, a penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. It's breach of contract, okay? And they're not saying anything about that, and that's why it's vague. That's another reason. That's why it's vague, because they're not saying it's breach of contract. They're just saying it's penal. And so, and I'll go on here. A penal action is one entirely and on statute brought with the sole object of recovering a penalty and forfeiture as punishment for a specific offense, while a remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit brought for the recovery of statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions on the one hand, closely related to criminal prosecutions, and on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. And a penal action is a quasi-contract. It's quasi-criminal. And this is a subset, okay? And I've actually heard of people going into these courts. I've never done it, but I've heard of people that went in there and they ask them to plea, and they say, I plead non-assumpsit. And the case disappears, okay? Because they're saying, I know your game, and I don't want to play. And anyways, assumpsit in its origin is an action of tort, soon was transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. That's why it's vague. It's void for vagueness, because they're not telling you this is breach of contract. They're not telling you any of this quasi-contract. That's something only lawyers could dream up. Don't get me going. You're going to get me going here. Anyways, based at first upon the express promise, it was afterwards supported by an implied promise, and after a fictitious promise. These lawyers lay awake at night, and judges, they're making money off of this. It was introduced as a special manifestation of the action in the case. It soon acquired the dignity of a distinct form of action which superseded debt. See, and they're talking, these were all commercial terms. Became concurrent with account, a commercial term, and case upon a bailment. These are all warranty, bills of exchange. Those are commercial terms, and competed with equity in the case of essentially equitable quasi-contracts. So both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. And so a quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of the facts under circumstances that making inequitable. Okay, so the only place that these things happen is in a court of equity, one of these martial law courts. That's why they got to get martial law going, okay? They got to get martial law so they can start assaulting you with these and populate the prisons. That's why they want to populate the prisons. Yeah, don't get me going. Quasi-contracts require minor estate entity. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Okay, so that's where the minor estate comes in. So they gotta bring in this minor estate. They got to have martial law. There's a bunch of things that have to be in place, and then they can start populating their prisons and making all sorts of money off it. And that's exactly what's going on. And it's all color of law. And this is 31 CFR 363.6. Entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, individual, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. A minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years, but has not yet taken control of the securities contained in his or her minor account. So again, and they're not making it. First of all, if there is a procedure on how you can take control of the securities, they're not making it available. Number one, and number two, if it is, it's in the Code of Federal Regulations, and regulations are for government employees only. And so it's a contract with the devil is what it is. If you want to get involved in that, it's a fraud is what it is. That's the real problem, is it's a fraud. And if you participate in the fraud, you cannot claim fraud. And I was going on and on with someone that, in the chat over this. And so it's a fraud. And if you participate in the fraud, and also under equity, you have to have clean hands. And if you participate in the fraud, you don't have clean hands, and they will never give you a remedy, which is used in the minor estate entity in the Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia outside not exceeding 10 miles square. And this is National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress can give jurisdiction to the federal courts by virtue of Article 3. So, in other words, if you're being attacked, if you're a state national and you're being attacked, it's not an Article 3 court. There are no Article 3 courts, okay? The only Article 3 court is the one that we're going to meet tomorrow and have an Article 3 court. It's the common law court. The Supreme Court is not an Article 3 court. It would be if they didn't have bar members populating it, but it's not. The Supreme Court is not even an Article 3 court, and none of the other federal courts are Article 3, and they know it. And if you read that WFAA TV case, they even bow down to the common law court. That's the real Article 3 court, and they'll bow down to it in a heartbeat if you do it right. Anyways, with plenary dictatorship jurisdiction, right? So it says, in other words, remember the Kavanaugh hearings when Kavanaugh was being interviewed for the Supreme Court by the Senate, and they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And that's because of the Commerce Clause. It says it right here. Congress has exclusive legislative jurisdiction. Remember, the Downs versus Bidwell, the Supreme Court said, the dissenting opinion said that there's two national governments. One operates within the Constitution, the other one's operated by Congress outside and independent of that instrument. So Congress has exclusive legislative jurisdiction to the federal courts by virtue of Article 3. In other words, Congress have, I said that wrong. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia and through their plenary power nationally. That's dictatorship, folks. That's no rights. That's they can do anything they want. Covers those citizens, even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And so, again, if you're in a plenary jurisdiction, it's a dictatorship. You have no rights. They can do anything they want. They're nothing but a bunch of thieves and pirates. And at the end of the day, you know, all political power comes at the barrel of a gun. That's at the end of the day, when push comes to shove, that's what it might come to. I don't know. I'm hoping it doesn't. I think that there's some good things that are happening, but at the end of the day, that's where it might come down to. The said plenary jurisdiction, plenary courts full and absolute power over the subject matter and the parties in the case. Absolute power over the subject matter and the parties in the case. Total power. Plenary, full, complete, entire. Black's Law Dictionary, 9th edition. The other one was Black's 8th. Plenary. This is Bouvier's. Courts of Admiralty and English ecclesiastical courts, causes in the suits in respect of the different course of proceedings are termed plenary or summary, okay? So, again, it's plenary, okay? That's total. This is taken from Wikipedia, which is very similar to Legal Information Institute, and that's the reason I'm quoting it, because Legal Information Institute's a really good source, and Wikipedia is kind of ho-hum, but they can be right. They can be right. Excuse me. Plenary, a plenary power or plenary authority is a complete and absolute power to take action in a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power under Legal Information Institute. Complete power over a particular area with no limitations. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. In violation of Article 1, Section 8, Clause 17, and that's what I do, is I'll file felony criminal complaints against them for perjury of oath for bringing the District of Columbia outside 10 Mile Square. I think that's one reason they don't want to talk to me, and I kind of like it that way. And so this is Article 1, Section 8, Clause 17, to exercise exclusive legislative jurisdiction in all cases over whatsoever over such district not exceeding 10 Mile Square. Anyways, no corporation, including the state of Texas or county of Tarrant, Inc., has standing to say anything to any man or woman, and that's Rundle versus Delaware. Therefore, the real parties of interest are Lori Varnell, Nathan Martin, Anastasia Frayne, Elizabeth Beach, Harry White, and Kevin Russo. The indictment fails to say it was a true bill, therefore it fails to be a true bill of indictment. And there are no minutes in the court showing that the foreman of the grand jury, witnessed by a minimum of 9 grand jury members, read the indictment into the record as required by Texas Code of Criminal Procedure 28.304. Therefore, there is no indictment, no probable cause of a crime, and it's a malicious prosecution. During the show trial, Elizabeth Beach testified to the jury that the indictment is a true bill of indictment. Elizabeth Beach forcibly entered a plea without explaining the nature and cause of the accusation. Because Lori Varnell and Elizabeth Beach are using the Commerce Clause, Article 1, Section 8, Clause 3, and quasi-contracts against Deborah May Carter with their minor estate entity, the private international law known as the Uniform Commercial Code applies, which is known in Texas as the Texas Business Control and Commerce Code, and controlled and governed by Unidroit in Rome and the Vatican. Deborah May Carter does not have the right to not have to reserve her rights to be able to assert them even in commerce. And this is a U.S. Supreme Court. This is one of the things that they kept saying is if you want to have rights, you got to assert them. Well, bullshit. To presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserved the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head. And this is Justice Cardozo, Supreme Court of the United States, delivered the opinion of the court. Even sovereigns may contract without derogating from their sovereignty. The challenge to jurisdiction filed into the case is evidence of the non-existence of jurisdiction. A kangaroo court is a sham legal proceeding in which rights are totally disregarded, and the result is a foregone conclusion. And so now we're going to get into some of the other stuff. I think that pretty well covers everything. Let's see. Oh, no, we'll cover some more stuff here. Deborah May Carter was denied trial by jury. Deborah May Carter was denied assistance of counsel of choice. Deborah May Carter was denied compulsory means for obtaining witnesses in her favor. Deborah May Carter was denied access to exculpatory evidence. Deborah May Carter was denied due process of law. Deborah May Carter was denied discovery or access to the hearsay evidence they were using against her. Deborah May Carter was denied an advocate under the Americans with Disabilities Act. Deborah May Carter was denied a neutral and unbiased Article 3 judge. Deborah May Carter was subjected to cruel and unusual punishment with an ankle monitor for 3 years and was not allowed to work or leave her property or go to church in violation of the 7th Amendment. Article 8 in amendment, The power to create presumptions are not a means to circumvent constitutional requirements. Elizabeth Beach is operating an inferior court of limited jurisdiction and derogation of common law. And this is American jurisprudence. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Accordingly, where a court of general jurisdiction undertakes to carry a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. It is familiar law that when special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. Elizabeth Beach is operating an administrative court. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of the legal authority and without regard to his own judgment or opinion concerning such acts' propriety or impropriety when a given state of facts exists. This discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. When acting to enforce a statute and its subsequent amendments to the present date, the judge of a municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent of the involved agency. They're bought and paid for clerks. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature or otherwise, act as mere clerks of the involved agency. See, what page is this? Oh, we'll see here in a minute. And this administrative court is working for the executive branch of the Texas Penal Code and imposing their quasi-contract. The word administrative is synonymous with the word executive. The word administrative connotes of or pertains to administration, especially management, as by managing and conducting or superintending the execution, application, or conduct of persons or things. Black's Law Dictionary, 6th edition. Administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. Elizabeth Beach is in bad behavior and has ceased to be a judge in this matter. An officer who acts in violation of the Constitution ceases to represent the government. If government officials attempt to enforce an unconstitutional law, sovereign immunity does not prevent people from whom the law harms from suing those officials in their individual capacity for injunctive relief. This is because they're not acting on behalf of the state in this situation. And this is immunity of officers of executive branch of a state as not absolute. It has been settled that the 11th Amendment provides no shield for a state official confronted by a claim that he had deprived of another of a federal right under the color of state law. Elizabeth Beach is a tyrant, and this is Two Trees of Government by John Locke. Tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. Well, this is page 17 and 18. And it's a total of 23 pages. So we're getting close to the end. We're not going to go through all the other stuff at the end, but these are court citations, and this is all stuff we're bringing up that the common law court is using. And again, this is a proposed judgment only that I prepared to try and speed things up. The common law court will, at the end of the day, they decide, the 12 jurors will decide what it's going to say. And this is just proposed just to get it started so that we can hopefully speed it up and move things along, because we have several of them that we want to talk about. Anyways, and this is making use of power anyone has in hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law but his will to rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power, that is put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Trees of Government. Kids in high school should know this. Book 2, Chapter 18, Section 199 and Section 201. Elizabeth Beach cannot do anything judicial, like issue orders, convictions, or judgments. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there is no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. And that's a federal court case quoting a Supreme Court case, Bradley versus Fisher, which is quoting 10 Coke 68, which is 1500s. Elizabeth Beach and her Tarrant County Criminal District Court have deprived themselves of subject matter jurisdiction, and all of her orders and judgments are void and an absolute nullity. And then it talks about void judgments here. A void judgment is one from its inception was a complete nullity and without legal effect. A void judgment is one which has no legal effect, force, or effect whatever. It's an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and any place, and it need not be attacked directly, but may be attacked collaterally whenever and wherever it's interposed. And so what we're thinking about doing, quite frankly, is bringing a collateral attack. A void judgment, insofar as it purports to be a pronouncement of court, is an absolute nullity. A void order may be attacked either directly or collaterally at any time. A void judgment is one which from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual to bind the parties or to support a right of no legal effect no legal force and effect whatever, and incapable of enforcement in any manner or to any degree. And Brutum Fulman. Okay, and I went and filed a lawsuit in state court and against FedEx, and FedEx removed it in the federal court, and I didn't want it in federal court, so I told the judge in paper. I never went into court and did this, but I told him I have nothing but contempt for you and your so-called court. You have an inferior court of limited jurisdiction, and everything you do is Brutum Fulman. And I've never had a judge be so nice to me after that. I'm telling you, I felt guilty afterwards. Anyways, Brutum Fulman is an empty threat. A judgment void upon his face, which is no legal effect, or judgment, no judgment of all, and by which no rights are divested, and from which none can be obtained, neither binds nor bars anyone. Elizabeth Beach is violating Deborah May Carter's right to be let alone. Okay, and the rest of it is just felonies and stuff like that. Actually, we can probably take that out of there because it's already there twice.
So FedEx was one of the 5.
No, actually, I didn't take that one to the Supreme Court. But anyways, so these are all now so they're all wrongdoers, and sometimes I name them personally, and sometimes I just name all of them because they're all doing it. And so that's it. That's page 18, and it goes to page 23. So we'll just skip all of this and we'll go right to the end here. So this is wrongdoers do have an oath to support the supreme law of the land and knowingly, willfully, and intentionally hold a show trial at their kangaroo court, as evidenced by the documentation, is self-supporting and in and of itself in favor of Deborah May Carter against wrongdoers of this case. The wrongdoers are guilty by their own actions and inactions, and thus are guilty beyond shadow of doubt of all charges, allegations brought against them in this matter. And after due consideration, finding of facts are one Supreme Court exclusive to the people by order of the people in or for the United States of America for Tarrant County, Texas Republic, finds private judgment, lien, and decree against affiant demandant and against wrongdoers in the amount of $1 billion in silver coin or the equivalent in Federal Reserve notes to be paid immediately in full without further delay to Deborah May Carter or her assigns at their direction, backed by the full faith and credit of the United States, and further the minor estate entity and its associated Treasury direct account is hereby ordered to be dissolved and liquidated immediately, and further the above finding of facts and conclusions by the jury is not reviewable by any other court of the United States except as set forth under the 7th Amendment, nor subject to trespass upon case DC 24001 by the judicial power of the United States, see the 11th Amendment of our national Constitution. And so then these are places where there are all the jurors, the 12 jurors, 4, 6, 8, 10, 12 will sign. And then there's also going to be an attached document where they'll review documentation and they'll sign, saying that they reviewed it, like they did in that WFA TV case. So if you want to see how that's done, you can go there and see it. And so then this is where a notary duly commissioned and privately bonded by the people in and for the United States of America for Republic of Texas hereby attest and acknowledge by the above jury's signature are the ones chosen and have been duly presented with the facts and testimony in relation to the character of the parties and the facts set forth in this affidavit. So they have and there's a notary seal. And that's all there is to this document. There's another page or two that will be exhibits that are circulated amongst the jury so they can review the evidence associated with this case, and they can have a chance to, if they have, it's going to be up to them. Okay, so I'm just trying to present something and speed it along as much as possible so that it's easy. So that we have like about 5 that we'd like to try and cover tomorrow. Although usually we get like about 3 of them done. So if we can get 3 of them done, I'll be happy, or maybe 4. But I'll have 5 ready to go, and so that's what we'll be doing tomorrow. And so again, this is common law. and I don't particularly care. At common law, we can do anything we want. Okay, we are the king, and they bow down to us, and so they have nothing to say. But I use those court citations to support everything that we say, just as a courtesy more than anything, to support everything we do. So I've got 5 of them here ready to go, and I'm going to probably start printing them off here pretty quick before I go to bed. I got to do some things in the morning too, but so that's where it's at. Does anybody have questions?
What's the time frame you're putting on there?
What do you mean?
Well, how much time are you giving them to reply and, come to a conclusion about their new hearing?
Well, we will have our common law court. Everybody will be in the room, and they'll be expected if to sign this common law court order, and if they're not comfortable signing it, then hopefully there'll be enough people in the room that are comfortable signing it. There's been times when some people didn't want to have anything to do with it, and that's fine. I'm not trying to force anybody to do anything they're not comfortable with. As far as anything else, I'm not exactly sure what you're talking about. What we're thinking about doing is she has appealed her particular case. She's got a bar member. They've given her assistance, one of the bar member liars, and so we're debating about we're going to file bar grievances against them, and they're probably going to want out. The question is whether we're going to let them out or not, and because we might keep them because they might be useful, in there. But so we're what we want to do is either, if there's an appeal, to attach this to the appeal as evidence, or to file a collateral attack in federal court. And a collateral attack, remember the void judgment talked about collateral attack. So we'll file a collateral attack in the federal court and, proceed that way. So we're still, right now, she's asked for a new trial. I haven't seen an order granting a new trial yet. And so we'll see what happens. You know what I mean? It's kind of like a wait and see. There's supposed to be the 20th of September is a deadline for filing supposed to be a certification of right to appeal. And so we got to wait, and that's part of, we filed a notice of appeal, and then a lawyer got involved, and they filed a request for a new trial. So right now we're kind of up in the air, and we'll see what happens. That's all I can say. I don't know what's going to happen, but we're thinking. It gives us time to think about how we want to proceed. Right now, we just want to get this thing in place so that we can, have that done and be ready for the next step, whichever step it is that we decide to do.
Yeah, get some relief for this poor lady. Is she still wearing an ankle bracelet?
She's in their jail right now. She's 65 years old, and she's in their jail. But her spirits are high. A couple people went down and saw her today, and she seemed to be, her spirits were high, and she was under a lot of stress when that trial was going on. The lawyer got fired, and the judge wasn't. She was getting stonewalled and blocked everything she tried to do, and then they went and convicted her and sentenced her to life in prison. And so we'll see.
Life?
I think that we can. Yeah, life. Yeah, exactly. Yeah. Don't get me going. Yeah, Texas courts are they make money off of this. Okay, I'm telling you, they make a hell of a pile of money, and so there's no justice that goes on in Texas, and that's why you don't tell the enemy it's the enemy. You never tell the enemy what you're going to do. You think it's bad in Canada, you go to Texas. But so it's the enemy. It's warfare. It's full out, knockdown, drag out warfare, and that's why I say, I'm hoping that Trump is going to get something going on his end. Actually, when they were down with her in the jail, she said that there was a lot of people that were disappearing out of that jail, and she thought that maybe they were going home. And so they don't tell you. And so if they're being like that guy that was talking about that Chevron case, it's entirely possible that those cases are being vacated. And I hope that's what's happening, but we can't count on that. And we have to, it can't just come from one guy. It's got to come from all of us. And we need to know the law and break it off in their ass. And so, that's what we do. And so it ain't over. There's a friend of mine that we're going to be doing a judgment for him, and he's been convicted for IRS issues, and he's supposed to get sentenced here at the end of this month, and we're hoping to get one for him, and then use it as evidence for a petition for writ of mandamus, and ask the Court of Appeals to order them to prove jurisdiction. And so we'll see. It's a crapshoot. You just have to do the best you can.
Okay, that was my point, Glenn. That was my point when I talked about that case. That you're proving my point exactly. So if the Chevron case, deference case, has been overturned, and now the judge can decide the ambiguity and which contract administration. You have to mute your mic while I'm talking, because I think I'm getting an echo. So if someone walks into that courtroom under presumption and assumption of contract, the judge now doesn't really have to go by the precedents based on corporeal affairs. That's what he had to do. He had to write his neck before this. But now that he doesn't have to do that, it's going to take time for all the courts to return to equity, and those judges start practicing the spirit of the law, the intent, back to the intent instead of the literal interpretation of the terms agreements of the contract, whether it's presumed, assumed, or not, implied or stated. That was my point. So anybody that's caught up on a Barratry timeline, the only way to move that court is to come back home, return to their substance, their equity, and quit playing in law forms. The only way to win that game is not to play that game. You said quasi-contract. That's right. These people can sit around and devil all day long. If you devil with them, you might have a problem.
Well, actually, if you're going to be in there, but this is common law, and that's different, and they can't say anything. They got nothing to say about what we're doing. And if you take the time to read that WFAA TV case, you'll see what happened. And you read the other cases, it talks about some other cases in there, and you'll see what they did. And so for those people who don't have access to a common law court, then you might have to do what baby Bobby Christ is saying. But as far as we the people and we the people make the law, we the people are the law. And so and we can't wait around waiting for one of these Baal priests to get off his ass and do something. And this is going to create a big problem for them. And so we'll see. That's all I can say. But because they are just nothing but a bunch of thieves and pirates. And so we'll see. There's always appeals, and that's what I do. Is I create appealable issues. These lower courts, you're never going to see justice in the lower courts, and in the appeals courts, they have to follow the case law, follow the law. And the lower courts, there's a thing called the law of the case, and so they'll just railroad you. And if you don't appeal it, then you agree to it. And so then it becomes a contract. And so that's the point, is that they're just nothing but a bunch of thieves and pirates. And I've been in there, and I know exactly what that's all about. And so we're trying to help this lady, and I'm trying to help this friend of mine, and I think that we got a good chance at getting the Court of Appeals to basically, if it's successful, if this Court of Appeals case for the mandamus is successful, they'll just dismiss the case, and that'll be the end of it. And so, you know, we'll see. That's all I can say is we'll see what happens. But it's never over till we say it's over. It's not up to these bail priests. And if you're subject, if you don't have access to a common law court like this, to people that you can network with, that you can get together and do this, then, you know, I feel for you. You need to. It's, you know, I mean, I don't know what to say. You know, you just got to do the best you can. They sell people into slavery all the time. It's satanic. It's diabolically evil, is what it is, and they're Satanists, and that's why, you know, again, at the end of the day, this is the same stuff that went on that precipitated the War of Independence, and you know how they settled it, at the barrel of a gun, and that's what might have to happen this time too. And so, if we the people are prepared to do something about it, it might not come to that, because there's some good things that are happening with Trump and with the Supreme Court. So hopefully the good things continue, and all of this stuff gets turned around. But it's a big ship of state. It takes a long time, and we the people need to start stepping up and taking care of business, and doing our part too, because we cannot, you know, if you think about it, we have the best justice system money can buy. And so you get what you pay for, you get what you deserve. Is it going to be you, or are you going to rely on these pirates? This is all diabolically evil, and we the people need to start taking care of business. Anyways, does anybody else have anything?
People just don't get the message, do they? They try to tell us all the time, this is just us.
Yeah, you're right. It's like, I feel like I'm flogging a dead horse sometimes, and I don't like repeating myself. But even then, I wind up doing it. There's people in the chat. I was having to repeat myself, and I've got a website, sovereigntyinternational.fyi, and you can go there, and there's a link. Matter of fact, maybe I'll even bring it up and show it on the show it on the yeah, so I'm sharing it right now, the sovereigntyinternational.fyi, and if you scroll down, there's free videos and read files. So if you go to the free videos, these are links to YouTube videos. They're hard to find on YouTube, so I organized them. I have a webmaster, so I got my webmaster to do it, actually. But they're organized by topics. So the first one is the do-it-yourself kangaroo court series. There's peace officers versus pigs and the difference, and martial law, and common law, the ultimate solution, bar members. So each of these videos, the Form 1020 is probably the most useful thing that you can use. And I would highly recommend, I'm showing people about the Form 1020 all the time, because that thing, when you do that right, that is so slick. It's a 2-page form, and it's worked time and time again. International law, banksters, taxes, the Canada Revenue Agency thieves, bought and paid for media, do-it-yourself series. So there's different land asset protection, how you can have absolute title to your land, pigs in Canada. So there's different categories, and you can study based on topics. The Northeast Private Information Share videos, training videos, and so you can go to the free videos, and you'll have access to everything on the free videos. That's not all of my videos, by the way, but it's a lot of them. What I would suggest also is if you go to, there's also read files. What happens is that this is about a gigabyte worth of read files. What I do is all these videos that I do are PowerPoint presentations, and I go through the law and I explain it to people. And people have asked for, what's this court site and stuff like that, and it's hard to copy it. Well, all you have to do is come over here, and I turn them all into PDF files, and so then you can download the PDF file, and then you'll have access to the court cases, and so you can get it that way. So this is more than just PDF files. There's a bunch of there's generic forms on corporate denial affidavit. There's notice and demands, copyright truth affidavits. There's all sorts of generic forms here. There are Word files you can download and use them if you want. There's a bunch of books. There's about a gigabyte worth of stuff. Banker's Secret Manual. That's that Tom Schaff book. That one's yeah, I use that with a $29,000 credit card where I got a demand letter in the mail, and they said we demand that you pay this now or we're going to sue you. And so I sent them back a letter and I said, sure, no problem, you can sue me, but I intend to prove in court that you didn't loan me anything, and I intend to ask an officer of the bank and a CPA these 160 questions. And so this is the questions for bankers. Where is it? Q.
Only 160, Glenn. Only 160. Come on.
Only 160. Here we go. Questions for bankers right here. This 160 questions. And so but I'm going to ask an officer of the bank and this CPA this 160 questions and prove you didn't loan me anything. And then there's and I say, oh, by the way, if you want to have an officer of the bank sign this one-page affidavit saying that you actually did loan me a depositor's money, which I might add as a felony, then I'll reconsider my position. And 3 months later, I got a statement back in that account showing it had been paid off. So anyways, the point being is that there's a lot of stuff here. And so if you're looking for something, I would say look there first. Anyways, and then my book, I got my book available, and this is links to my different channels and stuff like that. Patreon is no good no more. They took it down. And if you want to send me donations, these are ways that you can send me donations. And yeah, that's my website. And then if you want it, there's subscription channels or videos that are available, and you can click on that to order. So that's available on my website, okay? And then there's my YouTube channel, and I'll share that next.
Are you going to be recording anything tomorrow?
No, I don't. I mean, this one I might upload to my YouTube channel, but I don't normally.
How to Conduct Your Common Law Court would be a good title. Or you probably already have that one, don't you? But part 2.
Okay, so I think you're looking at, let me look here. Yes, you are. This is my YouTube channel. This is my, that's my studio channel. Let's go to here. But my videos are hard to find on YouTube. And even if you go here, this is the front page of my YouTube channel. And even if you go here, this is how the videos come up. And I would highly recommend you go and watch my recent videos. And that's the most recent stuff that I've done. And then the recent live ones, those are the most recent ones that I've done as well. and so I would highly recommend you go and hit those. Some of those are not on my website yet, and so that'd be a good place to start if you want to watch some of my stuff. But so were you looking at? Was that looking at? Let me look again. You were looking at it. Okay, good. Excuse me. I wasn't sure if you were seeing that I was showing you, or if you were seeing that other page. Yeah, so this is my YouTube channel. YouTube actually took it down twice, and both times they send you an email and say, we took your channel down. If you got something to say about it, you can respond to this email. And both times I responded the same way. I told them, you're engaged in multiple felonies. You're violating my rights under the color of law. You're conspiring to threaten, coerce, injure, intimidate me in the free exercise of my rights. You're engaged in war crimes with your forced medical experiment, taking reprisals against me for my political beliefs, and you're subjecting me to your Satanism with your fraud and lies and deception. I'm going to sue your butt off. All your executive officers and board of directors are personally liable in their private capacity. Don't think I don't know what to do, because I've been to the U.S. Supreme Court 5 times. You're next. And 15 minutes later, my channel's back up. And the second time, what I did is I went and prepared criminal complaints against every member of the Google board of directors for all of those felonies. And I sent them to the FBI and the Provost Marshal General in Washington, D.C., and, the places I usually send them. And they fired the CEO of YouTube. And now they've got a new CEO, and it's not necessarily changed that much, but I guarantee you that stuff works. Okay, those criminal complaints and stuff like that stuff works, and you rattle their cage, and they don't want to. You get their attention. Anyways, I suppose that's about it, really. Does anybody have anything else that they want to talk about today? I mean, otherwise we might as well sign off. It's 11:10 here, which means it's after midnight Eastern time. We started at 10 o'clock Eastern time, so we've been going for 2 hours.
Yeah, I really appreciate you coming on tonight, Glenn, and updating us on what you're working on. I have a question, but I'll leave it for the end. If anybody else wants to ask anything about what you brought forth, I'll wait until the end there.
Hey, Glenn. I don't really have a question. I just wanted to thank you for what you do. I saw your videos on YouTube probably about a year ago, long before I was able to get into this group, and they were pretty powerful. So, good job.
Well, thank you. And my attitude is that I can't fight all the battles. I need other people being on point. So I'm not trying to peddle some unproven theories. Some of the stuff I have done in the past, I'm not sure that I do. Like what do they call it? There's some stuff that I have done that I wouldn't do. That's why it's good to watch my recent videos and see what I'm talking about right now. Yeah, there's some that I have done that I wouldn't do. I just can't remember right off the top of my head right now.
Canadian border pigs. You don't want to relive that shit again. I know that.
They're definitely border pigs. There's no doubt about that. And that ain't over either. That's not over. It's not over by a long shot. Matter of fact, that's what I brought in action with the Supreme Court. And I got a common law court judgment going right now that I'm going to present tomorrow over that. And I got a common law court judgment against John Roberts. He's the chief judge of the Supreme Court. And so, it ain't over by a long shot. It ain't over, and they're gonna rue the day they screwed with me. But anyways, so we'll see. I really think that at some point, we might have to invade Canada and clean it up for the Canadians, and I guess we'll see. That's all I can say. Although what I'm hearing is that there's supposed to be, Cliff High said recently that there's going to be an armed revolution in England, and where the English government's going to get overthrown, and by the people of England, and when that happens, it's going to affect Canada a whole lot, and so things might change drastically in Canada when that happens. We'll see. He said that it would affect Canada the most, but he said it also affect Australia, New Zealand, and other Commonwealth nations. But he said it would affect Canada the most. So we'll see. It ain't over by a long shot. So yeah.
Yeah, well,
Anyways,
we need some help up here because the shit that's going down and they're allowing is just out of control.
Yeah, I would say, Texas is we have our problems here. There's no doubt about it. But they and Arizona. I mean, we definitely have our problems, but things are changing. And like that guy that was talking about the Chevron case, things are changing, and but it doesn't happen that fast. And and we the people. That's why we the people need to step up and start doing our part. It can't come from one guy. It's got to come from everybody. And at the end of the day, I think that we're going to see the time when Cliff High said that he saw it, where everybody's going to be armed at all times, and there's going to be citizen patrols, and they're going to call up the militia, and so I'll be on the militia. Everybody will be on the militia, and so that's coming, and so I'm ready. I'll do it in a heartbeat, and it's gonna get ugly, and that's what's got to happen, but when it's all done, things are going to be wonderful, and we're going to have but it's going to be ugly. He's actually, what I'm hearing is that we're going to go to war with China, and so it's going to get really ugly, for probably about the next, maybe 10 years. It's going to get really ugly. But so we'll see.
Have you seen the document that Trump wrote to write off his conviction? Apparently he wrote a bill of exchange to set off his recent conviction. Have you heard anything about that?
No, I haven't. I haven't heard anything about that. It wouldn't surprise me. It's all fake money, and so it certainly could do it, especially somebody like him that is in the middle of it. I mean, the president, if anybody knows about what's going on, it'd be the president, and so if anybody knows how to resolve that kind of issue, I mean, they're just a bunch of thieves. They're making it up as they go along, and it ain't over, and so it's gonna. In the next 2 or 3 months is going to be. I've heard there's going to be an October surprise. I did a video about current events. I would highly recommend it. It's the live one, the live stream that I did, and it's the most recent live stream that I did. I did it here at we have it was a Tuesday meeting we did last Tuesday, and I would recommend you go watch that, because I think it kind of covers what I'm hearing. It goes through stuff that we know are facts, and then it goes through stuff that is I've heard, and I have no idea. There's no way of proving it. It's just hearsay, and but it's interesting hearsay. I got to tell you that. And so I would recommend you go and watch it's the live stream, the most recent live stream, and it was done last Tuesday, and it's just about current events.
So about securing your voting, right? That's the big question that you must be wondering about, how you're going to avoid the Dominion voting machines.
Oh, I don't think the Dominion voting machines are going to be used again, and that's why I say watch that video, because I go through that stuff. I don't think there's good reason to think there might not be an election. We'll see what happens. What I'm hearing is the Democrats are going to cause something that will delay the election for a long time. And Trump he is commander in chief, and the military is going to be forced to step in. At least that's the rumor. That's I have no proof, but I think that's my opinion. Actually, the military will be forced to step in, and they don't want it. Quite frankly, they don't want to be mixed up in that stuff, and but they're going to be forced to step in, and what will happen is that, and so then, because what will happen is there's all sorts of evidence, and I talk about it in that. There's all sorts of evidence of foreign interference in our elections, and particularly China. Okay, and that's why I say we're probably. I'm sure we're going to be going to war with China, and the foreign interference in our elections is there's loads of evidence, and so watch the video. I go through the evidence that I know about. Some of it, a lot of it, has come out in court cases, and so Trump had issued an executive order for Homeland Security to give him a report on foreign interference in our elections, and they refused. And he was going to sign the Insurrection Act, and what happened is Sidney Powell left at night, expecting to come back the next day to prepare paperwork so that he could sign the Insurrection Act. And overnight, in the middle of the night, he met with some generals, and he often met with generals in the middle of the night. I'm thinking they're probably the White Hats, but he met with some generals, and they told him that that he could certainly sign the Insurrection Act. It was within his power, but if he did, that they believed that within 6 months, just like when Lincoln signed the Insurrection Act was passed by Congress in like the 1790s. Anyways, if he signed the Insurrection Act, they believed that we would be in a civil war within 6 months, and that if we did get into a civil war, they had gamed out all sorts of civil war scenarios, and the republic does not survive. And so Trump chose not to sign the Insurrection Act. He needed to wake up people, and if you look at what he's been doing, that's exactly what he's been doing. And so he needed to wake people up to what's going on, and he's been doing a really good job of that. They see the corruption in the courts, they see all this corruption, and so he needs the people behind him, and the military needs the people behind him, and that's where the militias come in. And so, how this all plays out, I have no idea. I don't think anybody really knows. To some extent, even the military, the White Hats, are doing the best they can. But they have a thing called continuity of government. And they don't want people killing each other in the streets. They don't want a civil war. They're trying to prevent that. But they also need to make sure that things are relatively stable. People need to be able to buy gas so they can go to work, and that kind of stuff. And so the bankers, what I think is going to happen, and this is again hearsay, that what will happen is when the military steps in and takes control, I don't know exactly when that's going to happen, but sometime in the winter, that they're going to crash the markets in April. April is a satanic holiday, and so that's a good time for them, that they like to do that kind of stuff, and they'll crash the markets. And it'll be like a big crash. Their attitude, these people are Satanists, okay? They don't care how many people they kill. They want to kill people. They want people gone, and we're useless eaters. and so the more people they kill, the better, as far as they're concerned. So they will burn the house down rather than give it up, and so that's what they'll try and do, and they'll crash the markets in April, and so I think that we'll see. That's all I can say. I think that that's like major opportunity for anybody that's ready for it, and we'll see.
Yeah, the banks here already have signs on the door. This location has no cash. Yeah, when they want to do the complete money changeover.
Yeah, no doubt. Well, I think Ripple is going to be the new, but I think that'll only be for a short period of time. When I say a short period of time, maybe a couple of years or 3 or 4 years or something like that. And Ripple will go through the roof. Matter of fact, I have some open orders to buy some Ripple, and what I'm figuring on, my target is $1,300. When it hits $1,300, I'm going to start selling it, and I'm hoping to buy it at 20 cents. And so when it hits $1,300, I'm planning on selling it, and I've got other cryptos. Trump actually gave a speech, or he was on CNBC. He was going to give a speech. They talked about it, about he wanted to make USA the world hub for cryptocurrencies. And I think that's coming. There's no doubt. If you listen to what Cliff High talked about, that's exactly what he talked about. And the world center for cryptocurrencies. And so, and what I heard, okay, this is just a rumor, when they stole the election, they went and they did find, this was on the news, that there was those Dominion voting machines were transmitting their data to an Italian satellite that was owned by an Italian defense contractor and leased to the Vatican. That was on the news. I remember that being on the news. There was a big shakeup in the Italian parliament. The prime minister resigned, and they have a new prime minister that's very conservative. Anyways, that was on the news. But what people
I heard it. Yeah.
What people didn't hear was that, and this is a rumor again, I don't know, but I suspect it's probably true, that we went, because of that executive order, foreign interference in our elections, we went and we seized 250 airplane loads of gold from the Vatican. Some stories say 650 airplane loads of gold. I don't know, but they say that there's 3 military installations that are bulging at the seams with gold. And so, I don't know, but I can tell you that I've heard it from people talking about it. And then one day I heard someone, it was an Italian news article where the Italian police said that around the election time of 2020, they saw U.S. troops in the Vatican. Now that would be consistent with us seizing a bunch of gold, and so that gives it a lot of credibility when I see stuff like that. But again, it's all rumors. I have no idea. I can't possibly say, and they're not going to tell anybody. Okay, if they did something like that, they're never going to tell anybody. They're just telling the enemy what we're doing, and so it's just rumors. Is all it is, and so that's why they don't tell people what they're going to do. It's because if they tell you, the enemy's going to find out, and they can't tell the enemy, because that's part of warfare. Is you never tell the enemy what you're going to do.
So they get the outcome of the election before everybody else does, and whatever they do from there, if it's going their way, I guess they don't do anything. Could that be right?
Well, I think that what happened is the military helped Trump basically defeat the election rigging on the first election in 2016, and then they wanted Biden to steal the election. I tend to wonder, if Biden's following white hat orders. I wouldn't be surprised. Again, they got to wake people up to what's going on. and they have to the people that are behind the scenes that are jerking everybody's chain, this deep state, they got to figure out who exactly the people are that are doing this. They have to build a case. They're entitled to due process of law just like anybody else. So they're not going to go and violate the law just because of something like that, because that's setting a bad precedent for the future. They got to give them due process of law. They got to build a case. And so that's what they're doing. And they want people to see what's happening so that when the shit goes down, everybody is saying, yeah, go, go, go. You know what I mean? And they don't have to worry about, you know, us killing each other in the streets and that kind of stuff. You know, what happened in the Civil War? You know, they say that there was 500,000 people killed in the Civil War. Well, the population of the whole country was probably about maybe 10 million at the most. And so you're talking a huge percentage of the population killed each other off. And they don't want that shit to go on, especially with 350 million people here. It'll be a bloodbath. And so that's why Trump did with the COVID thing. He went and forced them to change their plan, to bring out their plan before it was ready. And he forced them to do things that they weren't ready to do yet. And so that's why everything he does is he's jerking their chain and he's forcing them to come out of the closet and expose themselves. And the military's watching all this shit. And so, you know, there's people that are watching this stuff and they're seeing what's happening. And so, you know, it ain't over by a long shot. What I'm hearing is that we are winning big time. The good guys are winning big time. And you know, probably what will happen, I'll tell you right now, is, yeah, we'll probably go to war with China, but that's not going to be the end of it. I'll bet you that the real enemy is in Antarctica, and we're going to have to go down there. And that's where the real enemy is, I'll bet you. And the real enemy is the Nazis. After World War II, they went down to Antarctica and they have a whole civilization down there, and they're in secret. You know, when Tucker Carlson went and got interviewed by Putin, Putin told him, "You don't even know the name of who's running your country." And he was talking about Antarctica. I can just about guarantee you.
It's funny you should mention that, because the Germans were famous for being like, they get uprooting and moving into the mountains and stuff. That's what they're known. That's what German is, I guess.
Yeah, we'll see. You know, that's all I can say.
I have German blood too, but I'm not a Nazi. Yeah, they're not. But you're right. Might be some far away, far-flung place.
Well, we're all kind of Heinz 57, aren't we? I've got German blood. I've got French blood. You know, English. So we're all kind of like Heinz 57, but so you know, we'll see what happens. It's like they're not telling us, and it's all done. It's all done, you know, with deception. So they have to.
The satellite links, well, whether it was undersea cables or satellite links, they'd get those update, like the CIA phone desk at the Vatican and the MI6, MI5 phone desk and the Mossad desk phone. So I wonder if the goal went to pay for those desk phones at the Vatican. Just joking.
Yeah, we'll see. That's all I can say. I guess that's about it, though. I think we're about done. It's 11:30 now here. So thanks, everybody. Does anybody else have anything?
No, we can go on and on talking about Trump all night, but thank you for your views tonight on everything. Good luck tomorrow. I sure wish you were, you know, doing some recording of some audio of something or just bring back something next week to share with us and give us an update on it, please.
Sure. Did we record this one, by the way?
Yep, we're recording right now. So
good. Can you send me the recording? Yeah.
Yeah, I can do that. No problem. That's I think Michelle did that for you last time. No problem. So yeah, I'll get that done. Thank you very much. Have a good rest and look forward to hearing you again.
All right. Talk to you guys later. And thanks for listening. And thanks for your interest. And it's a networking thing. Nobody knows everything. And we need to share what we're doing. That's why I made that seal available. You can actually use that seal. That matter of fact, I'll upload that file. You can use that seal and make your own stamp. And but what I do, quite frankly, is I just put the seal on the document, and then when we get that document all signed, then what I'll do is I'll print the seal onto every page. I'll just print it over someplace on the page, and I'll move it around a little bit so that it looks like, you know, it's put on a different spot. It's not the same exact orientation and all that stuff as if, you know, somebody that had a seal that was actually. So every page is going to have that seal on it once we're done. But anybody can do that, and you can also take it down to Staples. You can send me an email, and I'll give you the black one if you want. You can get them to make you a stamp like that, and you can also make an embosser. And so that is what they gave me as a proof to. And so I've ordered a stamp, and I've also ordered an embosser. And so then you can have everything you need for your own common law court.
Get that.
Yeah, the plates are I think about $80 at Staples. So they are easy to come by, and an embosser is not something that is impossible only for judges and courts to use. We can get them made up ourselves.
Yep. And so and I'll even send you a my notary seal if you want. You just make up your own similar to that. Mine it's got my name on it, and it's got Texas Republic. It's just like the notary seal on that WFAA TV case, except instead of saying Texas State, it says Texas Republic. And so you'd have to modify it to your whatever state that you're in. But again, Staples, I got it made at Staples, and so you can get it done that way.
Okay, great. Thank you so much, Glenn, for coming on tonight. I look forward to Friday nights to get to hear you. So
All right.
We'll be talking.
Okay, sounds good. Thanks.
Nice.
See ya.
Take care.